942 words within target range. Here's the script. There is a legal instrument called the consent decree, specifically the one born from United States versus ASCAP. No one in Congress voted for it, no ballot ever mentioned it, and it has controlled how nearly every song played in America gets paid since 1941. 85 years, still standing. And you cannot vote it out because it was never a law to begin with. Here's what it actually is in plain terms. A consent decree is a settlement between the government and a company accused of breaking the law filed in federal court, signed by a judge, enforced like a permanent injunction. It isn't legislation. It isn't a regulation an agency wrote after public comment. It's a private deal dressed up as a court order, binding the parties forever unless a judge says otherwise. In 1941, the Department of Justice sued ASCAP and BMI, the two organizations that license almost all recorded music for public performance, for price fixing. Instead of a trial, they settled. That settlement became federal law for the music industry. It still is. Here's how something this big happened without a single vote. In the 1930s and 40s, ASCAP controlled licensing for nearly every popular song in the country. Radio stations, restaurants, dance halls, anyone playing music paid ASCAP's price, whatever ASCAP decided that price was. The Justice Department called it a monopoly and sued under the Sherman Antitrust Act. Rather than let a jury decide, ASCAP and BMI agreed to a consent decree. Stop fixing prices, submit to court oversight, and let a federal judge in New York set reasonable royalty rates whenever a dispute arose. Congress never debated it. No committee held hearings. A DOJ lawyer and a judge wrote the terms, the companies signed. And from that afternoon forward, the economics of American music ran through a courtroom nobody outside the industry had ever heard of. Here's the part almost no one realizes. That courtroom still exists. It's called Rate Court, a specific part of the Southern District of New York. And to this day, if Spotify, a radio conglomerate, or a bar owner disputes what they owe for the right to play music, they don't go to Congress, they don't go to the FCC. They go to one federal judge, operating under rules a settlement wrote in 1941 and lightly revised in 1950 and 2001. The judge doesn't set policy. The judge enforces a contract that predates streaming, predates television, predates almost every way we now consume music. Now here's the power it actually holds, over you specifically, whether you've ever heard of ASCAP or not. Every time a bar plays a cover band, every time a gym streams a workout playlist, every time a wedding venue hires a DJ, someone is paying a licensing fee whose rate was set, not by a market, not by a vote, by Rate Court. A small coffee shop in Ohio was sued in 2018 for playing background music without a blanket license. The fee schedule that determined what they owed traced directly back to formulas built into a 1941 consent decree. Songwriters themselves are bound by it too. They can't negotiate their own rates outside the system, because the decree requires ASCAP and BMI to license to anyone who asks, at a rate the court sets if the two sides can't agree. That means a working musician's income, an entire genre's royalty structure, and the licensing fee your local restaurant pays for a radio in the kitchen all run through the same 85-year-old court order. It was written to stop a monopoly in the radio era. It now prices music for a streaming economy no one in that courtroom in 1941 could have imagined existed. And here's the part that should actually worry you: none of this is a scandal. It's completely legal. This is exactly how the system was built to work. So why can't it just be undone? Because a consent decree isn't repealed like a statute. It has to be terminated by the same court that entered it, and only if the Justice Department itself moves to end it. In 2019, the DOJ reviewed both decrees and considered doing exactly that. Songwriters and publishers, the people you'd expect to want out from under it, lobbied to keep it in place, because without Rate Court, they feared losing the one guarantee that anyone must be licensed at some price, no matter how small. So the mechanism survives by mutual dependency. The government won't end it unilaterally. The industry won't ask it to end. And Congress, which never created it, has no direct lever to remove it either. Think about what that means for every other institution you assume is democratically accountable. If an entire industry's pricing can be set permanently by one settlement in one courtroom, with no legislature ever weighing in, ask how many other consent decrees are quietly running things right now. Police departments under federal oversight, hospital systems, banks. Each one entered the same way. No vote, no ballot, no public hearing, just a judge's signature turning a lawsuit's ending into permanent policy. The decree becomes invisible precisely because it works. No headlines, no repeal fights, just a rate court nobody watches, deciding what an entire economy pays. So the real question isn't whether the ASCAP and BMI decrees will ever end. It's how many other permanent, unelected settlements are quietly governing the rest of your life right now, running in courtrooms you've never heard of, under names you've never been told to look up.